Hello ladies and gentlemen, and welcome to today's Pragmatic Privacy Seminar. Today we're going to talk about what's been happening with privacy in Australia, and particularly as a result of the recent changes to the privacy law coming in on 12 March this year. So I guess if we just take a step back and look at privacy, back in 2001 or thereabouts, most of the developed nations around the world got privacy laws, including Australia. But then we saw, with the advent of 9/11, the privacy advocates lost a fair amount of their power because of the sort of perceived desire to give away certain privacy rights in return for the desire that people had to catch terrorists. And so we saw that as quite a significant movement across the world for the ensuing years. And then only recently has privacy really started to come back onto the front foot. And we see that particularly with some of the really large-scale privacy breaches that we've recently seen, particularly out of the US, but also coming into Australia. So we saw a massive breach in the US recently with Target exposing some tens of millions of people's credit card details. The result of that for an organisation like Target was that their quarterly revenue was down 46%, their CEO was forced to resign, and the cost of reprinting cards alone for the people whose credit card details had been compromised was over $100 million. So you can imagine the banks and issuing card issuers will be looking to someone, likely Target, to pay for that. So that's just the most recent. Obviously, Sony and PlayStation had a significant breach as well, which affected 1.7 million Australians. So we see that privacy is becoming a true business issue. And what we're going to talk about today is really Australia's response to that. So if we talk about what's happening with what we're going through today, the first thing we're going to talk about is, one, why do you care? Why do you care about privacy? What's the issue? And then going to talk about 7 tips to help get your organisation compliant. I should say at the outset that privacy law in Australia only applies to organisations that have turnover over $3 million. So if you are a smaller business than that, then the privacy laws do not apply to you. However, I should say that many organisations that I work with, even if the privacy laws do not apply to them, do regard that privacy is such a key issue, key trust issue for people, that they do actually comply as part of best practice. So they try to make sure they are complying with privacy laws, because all small businesses usually have a desire to grow into larger businesses. So good privacy practice is part and parcel of that. And if you're not compliant today, then once your revenue gets over 3 million, then you'll have to look at compliance then. So many organisations do decide as part of best practice to just get compliant. And the background behind this presentation is having advised now over 90 companies on what they need to do to be compliant with the new privacy laws. And so really it's about some pragmatic tips. So I'm not going to run through the law in slavish detail, but I'm going to talk really at a more general level about how to get compliant. So firstly, starting off, why do you care? So the main reason why you care is the enhanced powers of the Privacy Commissioner now. So you can see up there on the screen, Privacy Commissioner's got a lot of new powers, the most eye-catching of which is the ability to issue penalties up to $1.7 million for companies and up to $340,000 for individuals. Privacy Commissioner can also accept written undertakings from companies, and those will be enforceable through the court. There's also a variety of other things, including a proactive right on the part of the Privacy Commissioner to be able to conduct performance assessments, that is, audits. to come in and have a look at what's going on. So these laws came in on 12 March. I can say that the Privacy Commissioner has actually been active, and I know that the Privacy Commissioner is actually auditing organisations. So I had not originally expected that the Privacy Commissioner would do much in the way of proactive auditing, but rather would just respond to complaints. But I do know the Privacy Commissioner has actually been auditing. I have first-hand experience of that. So I think we can assume that the Privacy Commissioner will be using a number of these powers, so we'll actually be doing some proactive auditing, although this must be looked at in the context of the Privacy Commissioner is not a well-resourced organisation. I think at last count had some 3 or 4 full-time equivalents in the Privacy Commissioner's office. And then, of course, with the most recent budget handed down by the Abbott government, the Office of the Information Commissioner, where the Privacy Commissioner sits, has now been disbanded, and the Privacy Commissioner is now sitting under Human Rights. So that means that there has not been a lot of money to go around for really aggressive enforcement. But I think what we are likely to see from the Privacy Commissioner is some looking to try to find really brand name companies that have in some way infringed the privacy laws, and then the Privacy Commissioner will come to those organisations after having received complaints, and we'll talk to those organisations about the lack of compliance. And then I suspect they will in some way get written undertakings from those organisations, and those undertakings will be enforceable through the courts. And so to see how powerful that is for a regulator, one looks to the ACCC, where the ACCC has not had its greatest successes, generally speaking, in courts have not been through specific cartel actions and price fixing actions. Rather, what the ACCC does very effectively is it goes after organisations that it suspects are guilty of breaching the competition laws, and then gets written undertakings from them that those organisations will not engage in various activities, and they specifically set out what those activities are, and so they have an ability to dictate what those undertakings are, and then the organisation signs up to those undertakings, and then what happens, and this is where the real enforcement happens and where the ACCC has been very effective. If the organisation fails to comply with the written undertakings, then they can actually be enforced through the courts as breach, so breach of the undertaking is regarded as contempt of court, and so that is where the ACCC has been most effective. So I think we can see the Privacy Commissioner doing that, and I suspect over the next year the Privacy Commissioner will look to get some media exposure for some penalties and undertakings that they have received. And it's no coincidence that the Privacy Commissioner made a significant announcement on March 11, just on the eve of the new laws coming in on March 12, in relation to Telstra having exposed some 10,000 customer details in a privacy breach, and so the Privacy Commissioner used that particular breach as a way of bringing attention to the new laws, which only took place came into effect on March 12. So Telstra was not guilty of a breach of the new laws, but rather of the old laws. And so they had a very slim penalty, and that penalty, in fact, was only able to be enforced against them as a result of a breach of an ASIC-related regulation, and not under the Privacy Act. So these new powers of the Privacy Commissioner are really quite significant, and so that is definitely causing organisations to sit up and take notice. So if we look at now, what are the tips for privacy and getting ready for privacy? So hopefully as an organisation you've already done your work to get ready for privacy. However, I know a lot of people or organisations perhaps are not as privacy ready or compliant as they could be, and so what I'm going to do is to treat this as though you perhaps may not be as compliant as you could be, and some of the key issues on the pathway to compliance. So the first tip on that is to get management approval, because the new APPs, the Australian Privacy Principles, will likely require amendments to your systems, procedures and your policies. So for many organisations that means getting director, board or CEO approval for new policies, and also in some cases getting budget. And it is critical because privacy is a policy and compliance driven jurisdiction, so it's very important for your organisation to make sure that you do the work to get compliant. So I have had clients who've sent me in their privacy policies and asked me to just mark those up to make them compliant. But it's just not as simple as that. As an organisation, you do have to look at how you deal with personal information, and then you have to make sure that how you actually deal with it actually complies with the law. So it does require some work on your side. It's not just a matter of asking the lawyers to help out, as simple as that would be if that were just the case. But it really does require the organisation to think about how it deals with personal information. So the second tip for getting compliant is investigating your data flows. And this is actually more complicated than you would have thought, because it is a matter of trying to work with organisations to understand what they're doing with personal information. So what personal information is collected and why you collect it, how do you collect it, how do you handle it, where do you store it, and who do you disclose it to, very importantly. So those sorts of issues are critical. And if you look at the way to start this off is really to, you need a team to get together on this. So generally speaking, you need to work with a couple of key stakeholders within the organisation. The first thing to do is make sure that you've got senior management supporting the privacy investigation or the privacy audit. And so in some organisations that might be the CEO, in others it might not need to go all the way to the CEO, but you definitely need senior management to say this is really important, so make sure you comply with it and help out the audit. The second aspect is who should be on that group to provide the information in relation to the audit. So it doesn't need to go granular. Doesn't need to be all the salespeople or the phone operators or anything like that. But what should be covered is you definitely need someone from IT on there, because they are the ones who know how all the systems work. Marketing, because they are generally close to the end customers, and so they will know how they're advertising to them, how they're marketing to them. So that will be critical. And then, anyone involved, at a senior level with the sales function. And one of the critical areas to think about too is HR, because it is true that in Australia, employee records are not subject to the Privacy Act. So you don't need to comply with the Privacy Act in relation to information you hold about your employees. However, one thing to remember is that if you do keep information about people who perhaps apply to be employees but are not, but don't subsequently become employees, so they don't make it through the recruitment process, if you do retain that information, then that information will be subject to the Privacy Act. So be very, very careful with the HR issues. So some of the questions that you should be asking is, do you have a privacy policy? Is it freely available? What personal information do you collect? Is it reasonably necessary for one or more of the functions or activities carried out by the organisation? So you do need to think about whether you reasonably need personal information, because there is an obligation under the Privacy Act that you are only allowed to use information, or you're only allowed to gather personal information if you have considered whether you could do the particular transaction anonymously. So there is, at its core, you have to ask the question, could I do this transaction with this person anonymously, or do I genuinely need personal information? Do you have a separate collection notice that contains necessary notification matters? And I'll talk about the collection notice and the privacy policy in a moment. Do you have a simple opt-out function for direct marketing? So direct marketing has come in for a significant amount of change in the new laws. Do you have a process in place to allow individuals to access and correct their personal information? So you do have to allow people who are concerned, if they send you a note, you have to allow them to access their personal information and correct it. Do you disclose the personal information overseas? And we'll talk a lot more about that later on. There's a significant new regime in relation to overseas disclosure. And then do you have a procedure in place for dealing with complaints? And if there is only one thing that you take from this, and hopefully you'll take a lot of things from this discussion, but if there is one critical thing to come out of this, is that if someone complains about a breach of privacy, then act very quickly to ensure that that person's issues are dealt with and they're comfortable with the outcome. Because the problem will be, if they go to the Privacy Commissioner, generally speaking, the Privacy Commissioner will refer them back to you or to your organisation first to see if you can solve the issue. But if people do complain to the Privacy Commissioner, then that will raise the Privacy Commissioner's interest in you, and that then can lead to Privacy Commissioners coming in for audit and so on and so forth. So best to nip it in the bud. If you do get a complaint, make sure you deal with it very quickly, show the person that you take privacy very seriously, and make sure they're comfortable with the result. So tip 3 is to update your privacy policy and collection notice. So your privacy policy is a public document and it is visible to the Privacy Commissioner, obviously, because it's sitting on your website. And so it is a very visible sign of your compliance. And as I said, the Privacy Commissioner is actually having a look at people's websites and checking out their privacy policy. So this is unlike really any other area of compliance because it's so exposed. So you do need to make sure that your privacy policy is compliant. In terms of you've got certain issues that need to be covered in the privacy policy, and then you've also got a collection statement that you need to have. There is also a credit reporting statement. Now the problem with this is that's actually three separate documents conceptually. The credit reporting statement is really only relevant if you give credit, and that is so that's a very specific scenario which I won't go into here, but credit reporting statements do need to be done separately. We've then got the issue as to privacy policies and collection notices. So as I said, these are two separate concepts under the Privacy Act, and this has been a significant change. This is one of the major changes from the existing law, which is it is very specific now about what sort of information privacy policies must include. And so you can see there on the screen, privacy policies must now include the kinds of personal information collected and held, how personal information is collected and held, the purposes for which personal information is collected, held, used and disclosed, details of how to access and correct personal information, complaint processes, and then this is a new one and really difficult for some organisations to comply with, which is details of possible disclosure to overseas recipients, and if so, the likely countries, if practicable to specify. And I know that many organisations that use cloud computing, for example, if you're using cloud-based services, then generally speaking, many of the cloud providers are sending that information to servers located in the US or Singapore or similar places. So important to know where that information is going and be able to put that in your privacy policy. And many organisations find that very difficult to deal with because there's just not the knowledge about where their vendors are sending that personal information, particularly in the cloud scenario. So we've then got the separate concept. So this is that's the privacy policy. This is now the collection notice. So the notion behind the legislation is that the collection notice must be available at the time of collection of the personal information. And so you need to say, and these are similar to and cross over with what needs to be in the privacy policy, but slightly different. So you need to say in the collection notice the fact and circumstance of collection, where that is not apparent, reference to access and complaint processes, main consequences if personal information is not collected, names of laws requiring personal information to be collected if there are specific laws that require the personal information to be collected. So, I mean, there's nothing in the legislation which says you can't combine the collection notice and the privacy policy. However, I do know for a fact the Privacy Commissioner really does not like the idea of the collection notice and the privacy policy to be two separate documents. I don't think there's a specific regulatory requirement for that, but certainly the Privacy Commissioner would prefer that they are separate. So that's something to consider. Tip number 4 is to ensure that you check your consents. So consents are different to notifications. So if we think about personal information is basically, it's a notification-based regime rather than a consent regime, generally speaking, unless direct marketing is involved. So what I mean by that is if you want to use someone's personal information for the purposes of your business, then what you need to do is put in a privacy policy what you intend to use that personal information for. So, but that is notification, so you don't have to have them click an I agree to that if you want to use it for the purposes of allowing you to provide a better service to them, then you just say that in your privacy policy, and so long as that privacy policy is accessible at the time that the personal information was taken, then that's all you need. People just need to be notified. They don't need to tick a checkbox to say they consent to it, except in certain situations. And so direct marketing is one of those. So if you are proposing to use someone's personal information for the purposes of direct marketing, then really you do need to have consent to that. And so consent should be by way of some form of checkbox. I should say, if we look at spam, and spam is a good analogy to what's happening with privacy. If we look at what happened with spam some years ago, the ACMA, is the regulator for spam, they said, right, so we've got the new spam laws and you're going to get a period where you can we'll go softly on you, but then from a particular date we're going to go very hard on failure to comply with the Spam Act. And they did. And they, from the date when they decided to really strictly enforce it, they did penalise a number of very significant Australian and overseas companies for failure to comply with the Spam Act. And it is interesting to, we'll see, I think, the Privacy Commissioner do something similar over the next year, which is really try to get some significant wins against some very large brand names, so as to teach people a lesson and put people on notice that they are serious about privacy compliance. The other area which is very similar on spam is the ACMA has a sort of guidance note on spam compliance, and spam you require consent before you can spam someone, express or inferred. And express consent, the ACMA says that they don't believe that a pre-checked box is effective consent. I take a contrary view to that. I think that a pre-checked box is in fact can be regarded as consent, provided someone has had the ability to uncheck the box. So that's an area which is sort of still subject to seeing some law on that. But I think that if someone has the ability to uncheck the box and they choose not to, then I think that should show consent. Now back to checking your consent. So direct marketing, as I said, is very important to have the consent. It is relevant now. So we've never had the Privacy Act applying specifically to direct marketing. So we need to think about what forms of direct marketing there are out there. So if it is email, direct marketing by email or SMS, then that is going to be subject to the Spam Act. So you forget about the Privacy Act with respect to email and SMS, and just make sure you comply with the Spam Act. If the direct marketing is via telephone or fax, then you're subject to the Do Not Call Register Act. So you don't worry about the Privacy Act. It's really a matter of complying with the Do Not Call Register Act. So therefore, anything that falls outside, that is direct marketing, that falls outside of email, SMS, and telephone or fax, will be subject to the Privacy Act. And so the areas that are most relevant there, I guess, are hard copy mail-outs. So that was unregulated territory. That's now regulated. And then also online direct marketing. And that is an area that the Privacy Commissioner is very, very interested in. And it's obviously something that a lot of online companies do a lot of, and so retargeting and so forth. So before you do engage in significant online behavioural targeting, important to think through how the new direct marketing provisions of the Privacy Act do apply to that, because you may find that there are some concerns with that. It's also relevant wherever you have a piece of direct marketing, you now have an obligation to ensure that someone has an opt-out, so they can opt out of that. Also, something which we've never had before is if someone receives some direct marketing, then you can ask the company that sent you that piece of direct marketing how they got your name. And most organisations, in fact, every organisation that I've worked with, does not have the ability to identify, in fact, how they got the person's name in the first place. So that's a very significant new obligation, and one which any organisation which engages in a lot of direct marketing needs to think long and hard about. If you are doing multi-channel marketing, so you're going across phone, fax, SMS, email, physical, then you'd be best to manage direct marketing according to the strictest requirement for consent, which is really the Spam Act. Sensitive information can only be used for direct marketing with consent, so you need actual consent, no inferred consent there. A lot more work to be done if you are an organisation that engages in a lot of direct marketing. Tip number 5 is to identify the contact points with customers. So, as I said before, you've got to provide a collection notice and a link to your privacy policy on your first contact with the customer. You need to think about how you are actually contacting that customer. Remembering you only need to do it once, so you need to do it. So the first time you deal with someone, then you need to inform them of the privacy policy and the collection notice. Now, how we actually manage that practically is an interesting discussion. And so if you think about the online world, then that's relatively simple because those people are filling out forms. You can have links to privacy policies and collection notices and so forth. So that all becomes relatively simple and manageable. However, if you are doing telemarketing, that is harder because in a telemarketing environment, you do need to make sure that people are referring to a privacy policy when they are taking information from new customers and so forth. So, one of the things is to have that concept of, if you would like to hear our privacy policy, press 1, and then have people directed to a voice reading out the privacy policy. I doubt many people will ever press 1 to hear that, but that is a way to deal with that. And alternatively, if your organisation is not of sufficient scale to do that, then you need to bake into the process that the telemarketers are going through that it's very clear from the scripting that they refer to the privacy policy and perhaps refer the user to a website with the privacy policy. That's not great compliance, but it's probably sufficient depending on the nature of what you're intending to do with the information and so forth. So you really need to triage the risk there. In a hard copy world, so let's say people are coming into a store, and so it's sort of the offline world. In that case, then you do need to have a hard copy of the privacy policy available and have it clear in the scripting for the sales process that people are referred to the privacy policy before they give over their personal information. Moving on then to tip number 6 is review your service arrangements. So the first point there is allow for mandatory data breach notifications in future service agreements. So mandatory data breach notification has been very popular in the US. A lot of laws. I think there's roughly 42 laws in the US, separate state laws requiring you to notify people when there's been a breach, and the federal government in the US is now looking to consolidate that to one federal law. We've seen mandatory breach notification come in other countries as well, and we almost got it in Australia at the end of the last government. There was a bill which made it through the House of Representatives, and then it was, I think, about 45 minutes away from getting tabled in the Senate when the Kevin Rudd return occurred, and so everything went off the rails, and the mandatory breach notification provisions were then not passed. So they have subsequently been brought back before the Senate, and we'll wait to see where that ends up. We don't know quite where the coalition stands on that right at the moment. But I would assume within the next 2 years that we will see mandatory breach notification in Australia. And so I think it's important to ensure that your service arrangements are drafted in such a way that your vendors have an obligation to notify you should there be some sort of breach of privacy out there. So that's an important thing to put in there, because if you don't know that there's been a breach, then you will be liable here in Australia. In terms of overseas disclosures of personal information, as I said before, your privacy policy now needs to say if you are sending personal information overseas, and then you need to state which countries it's going to. But also important, you've got to now say, or if you are exporting data or personal information, then if it's going overseas, you as the Australian entity will be primarily liable for that information and for any breaches of the Privacy Act that occur by your vendor overseas. So the Privacy Commissioner will come and chase you as the customer here in Australia for any breach by the vendor. So that means you do need to think more seriously about what your agreement says with your overseas vendor about how they're going to help you in the event that there is a breach of privacy. And so one of those things may well be that they will certainly indemnify you for any loss that you suffer. For example, if you get fined by the Privacy Commissioner, or if you have to do an investigation into what's happened. And they will also have to, you want them to have an obligation that they will assist you in complying with any particular challenges that have come from the Privacy Commissioner as part of the investigation. So, if you're required by the Privacy Commissioner to produce documents or information as to how the breach occurred, you want to make sure that your vendor has an obligation to help you out by providing you with that information. So expect to see more time and effort spent on those sorts of provisions. Many organisations are considering cyber liability insurance. So what is interesting is that cyber liability, so the liability that an organisation or the loss that an organisation suffers as a result of a data breach, is not covered by the traditional basket of insurances that are held. So professional indemnity insurance, property insurance, workers' comp, etc. Any of those insurances, or just a general insurance policy, does not cover loss caused by a data breach. So, for example, if a hacker hacks into your system, that will not be covered. The losses associated with that will not be covered by your insurance policy. And so those losses might be, maybe you've got to do some forensics to figure out how it happened and stop the flow. Maybe you've got to get some PR people in to help out with what the messaging is going to be. maybe there's costs of complying with some sort of investigation from the Privacy Commissioner, maybe there's legal costs, a whole range of different costs. There's also the cost of putting the data back together if the hacker has in some way corrupted the data. So a number of significant costs that are in the uninsured space right at the moment. And so many organisations are considering cyber liability, and the insurance companies have seen this as a big new revenue area for them, and many of them have new and interesting products around cyber liability. Also, we are seeing people within contracts. So where you are engaging a vendor, an IT vendor, often there will be an insurance provision requiring that vendor to have a number of specific type insurance policies, professional indemnity, etc. What we are seeing is that customers are saying to vendors, well, what's your cyber liability insurance and how much of that do you have? So we could see customers asking vendors to be doing more as regards cyber liability insurance. So just on the tip 6 in terms of the specific provisions that you need to have in your service arrangements. Here is a list. This is a number of things. You can come back and have a look at this at your leisure, but I've covered off many of them. Really, it's a matter of how significant is the information that you're giving over and what would be the potential loss if there was a breach. So it's really thinking about those sorts of issues and how granular you need to go in those provisions. So just in relation to cross-border disclosure of personal information, one thing that is relevant now is that it used to be uncertain as to whether if someone got access to personal information which resided on a server here in Australia, but they tunnelled in via a VPN. So let's say, for example, you used a vendor that was doing help desk outside of Australia from Mumbai, and there was personal information which is available on servers sitting here in Australia, but they were able to access that information by way of a VPN tunnelling in from Mumbai. Then if they saw that information, that would be regarded as cross-border disclosure and therefore covered by the Act. So that's been made very clear now. It was uncertain before, but under the new Privacy Act, it's now very clear that that is covered. But any cross-border disclosure is treated as a very important issue, and the obligations under the Privacy Act are to take such steps as are reasonable in the circumstances to ensure that the overseas entity does comply with the Australian privacy laws. And so this wording is slightly changed from the way it was previously, but we think that likely reasonable steps would normally be you require the overseas vendor to enter into a contractual relationship that says they will comply with Australian privacy laws. This does create some concerns for more sophisticated vendors who've thought through the issues around that, because it may be that you don't want your overseas vendor to comply specifically with certain aspects of the Australian privacy law. For example, allowing someone to go directly to, let's say IBM is your technology vendor. You probably don't want one of your customers going directly to IBM and asking to see their information. You would rather them come to you and you will show them the information rather than going to one of your vendors. So you might need to think about how you put that in the contract and saying that, if the vendor is approached by someone, they will refer that person to you and that you will, make such access and correction as is necessary. The final tip is to review your security measures, and so with that we've sort of often wondered as to what the information security requirements are. What do we need to be doing as an organisation? And so the Office of the Australian Information Commissioner in 2013 put there what are reasonable steps to protect personal information. And so, as you can see, reasonable steps depend on the nature of the entity holding the personal information, the sensitivity of the personal information, the harm that is likely to result to individuals, how the organisation stores, processes and transmits personal information, and the ease with which security measures can be implemented. So as you can see, it takes into account a number of issues, and so it's a matter of considering, what is the appropriate level of security that you should have, given the sort of organisation that you are and the sort of information that you are carrying. So it is subjective to a degree, but certainly, there would be, minimum basis. So your ISO standards, as well as, certain technology measures, relevant encryption and intrusion detection, firewalls, as well as monitoring and review of that. And importantly, staff training and security awareness and education. And I think certainly what I have seen is that there are far more hacking attacks that are occurring, and really important for organisations to have considered what their information security is like, and making sure that at a board level they've made a decision around that. And I should say there is just one cautionary tale on that sometimes, and I've had recently a situation where a client had their systems compromised by an individual who did something relatively simple and figured out that they could see other customers' data. And so that individual sort of sent some information in, suggesting that they knew, about this. And so the question is then, should that individual get a reward? There's sort of bounty schemes that certain organisations have. Facebook just recently paid someone who was able to hack into their network a fee or a reward for doing that. Just need to be careful with those sorts of arrangements, because in Australia, in certain states of Australia, there is a criminal offence to conceal an indictable offence, and blackmail is an indictable offence. So arguably, if someone is trying to blackmail you into paying them some form of reward, that is an indictable offence, and by paying that reward, you can in fact be committing a criminal offence yourself. So just need to be conscious of that issue. So to round things out, really, it's now about organisations do need to think more seriously about personal information, and it's about a life cycle. The Privacy Commissioner does talk about personal information life cycle, so it's no longer just gather as much as you can and keep it for as long as you want. It's really about only gathering what you need and then disposing it when you no longer need it, and that's what the Privacy Commissioner is going to be looking for. Privacy Commissioner is going to be looking for organisations that have taken true steps towards compliance and have tried to educate their people about what's happening. Be careful of social media platforms. There's now an obligation in relation to unsolicited personal information. So even if you didn't ask for the information but you're provided it, for example, someone provides a lot of information on your Facebook page or something of that nature, you cannot use that unless you've specifically would have the right to use that under your privacy policy. So just need to be very careful about how that works. And then I guess finally, privacy policies, people did them in 2001, 2002 and then completely left them and no one bothered looking at it until now. That's not going to be possible anymore, because it's so specific what you need to include in your privacy policy that you need to be very careful that you update that continually. So I don't think it's a set and forget anymore. It's a matter of the privacy policy is now very much a living document, and so important to keep updating that as you change IT vendors. Perhaps information's going to new countries, or if you're gathering new and different sorts of information, then you need to update your privacy policy. So thank you very much for the opportunity to talk to you today about privacy. I do wish you all the very best. Thank you.